Hi, my name is Lauren Fields. I lead the domestic litigation team here at Roth Davies, LLC. Today I'm going to discuss what happens if your case is not able to be settled and you have to proceed to trial. In the event that you and your opposing party are unable to reach an agreement regarding your divorce or custody arrangement, and you've tried exhausting all other resources such as settlement conferences and mediation, then your case will proceed to trial to get you a divorce. At the trial, the court will have an understanding of what the outstanding issues are because you'll be required to have a pretrial conference. For example, if you have settled all of your assets and debts and only custody is at issue, then you would have a trial just on the custody issue. The judge will make the parties stick to the issues laid out in the pretrial conference, and the party who initiated the lawsuit will be the party who starts the trial. This is typically called the petitioner. That party will present evidence based on the testimony of witnesses and other documents collected throughout the preparation period. After the initiating party has presented all of his or her evidence and witness testimony, then the other party will have the opportunity to put on his or her witness testimony and evidence. This is typically called the respondent. During the trial, typically each party has called witnesses and questioned the other witnesses that the parties think is necessary to demonstrate to the court their position. Likewise, evidence that the parties believe is necessary is marked, labeled, and presented to the court for consideration. After the court has heard both sides' testimony, both witnesses, and seen the other side's evidence, he or she will typically take the case under advisement to consider the arguments and all the evidence before issuing a ruling. However, if the issues are not that complicated, sometimes you will get a ruling that day. And this is called a bench ruling, where he or she tells the parties his or her decision then and there. Typically, the court will issue its own written opinion about what he or she deemed was appropriate on the division of assets, custody arrangements, or any other issue lingering that was heard by the court. Trials can be very complex and scary. I try to make sure my clients are prepared as possible for trial by presenting them with questions I plan on asking them ahead of time and quizzing them on questions that I think the opposing counsel will ask. I do this with my witnesses that I plan on calling as well. If you have any questions or concerns about trial, please do not hesitate to give me a call at 913-451-9500. Thank you.